Hey guys, this is Karina.
This is Eric.
Welcome back to the Late Podcast. The law according to Eric.
Eric and Karina, together again for the very first time.
Fighting crime. All right, so the first topic we wanted to introduce is bankruptcy, which is what we specialize in. I was actually telling Eric yesterday where the word bankruptcy actually came from, and it comes from the Italians, which means bancarrota, which means broken bench. Because in Italy, the money dealers would work from benches or tables, and if the money dealer would run out of money, his bench or his table would be broken in half, and he was out of business. And that's where it came from.
Interesting to note that the word bankruptcy in Spanish is bancarrota.
Yeah, it is. All right, so let's start with this. So we focus mainly on the three chapters of bankruptcy, 7, 11, and 13. How do people know which one is the best one for them?
You don't really know right off the bat. So there are several factors that have to be taken into account when deciding what chapter of bankruptcy relief might be right for each particular case. If it's a business that has been struggling even post-COVID, even after reopening, but the business doesn't want to shut down, it wants to continue, it wants to operate, then there is Chapter 11. And within Chapter 11 is something called Subchapter 5, which is really focused for small businesses. This is part of what was called the SBRA that was passed under the Trump administration, which is carried over. And it's really meant to streamline business reorganizations. If you're an individual and you find yourself in a ton of debt, and the type of debt I'm talking about is what we would call unsecured. So credit cards, medical bills, cell phone bills, unpaid utilities, things like that. And you just can't climb out from under it, assuming you meet certain criteria, meaning your income falls within a certain range, your assets are worth a certain amount or less than a certain amount, or you have certain exemptions, you can qualify for what's called Chapter 7. Chapter 7 is technically a liquidation, but that sounds more daunting than it really is. Because most people that go into Chapter 7, or I should say whose attorneys advise them that Chapter 7 is the correct chapter, should take into account if they're homeowners or they have other assets or they have a lot of money in the bank or things like that, and then determine if they meet all the necessary exemptions to go forward with the Chapter 7 and not be liquidated essentially by a trustee. So what happens in Chapter 7, all chapters have trustees to some extent, right? But Chapter 7, it's an independent appointed trustee. There's a panel of trustees that work for every particular district. And that trustee's job is to essentially investigate what are called the schedules and statement of financial affairs that the debtor files to determine if there are assets that are not exempt that can be liquidated or basically sold in order to benefit the creditors of the estate. So while that sounds kind of scary, the truth of the matter is that it's actually a very fair way to look at it. If you're an individual that does not have a big giant house with a ton of equity and you don't have a lot of assets and cash in the bank, you're going to get your debt all wiped out and you're going to get a fresh start. And the whole process usually takes about 4 months, start to finish, and you're all done. And that's great. But the bankruptcy code is fair because it's not going to let you do that if you're sitting on a ton of money and a ton of equity.
Right.
So you either have to pay something if you can, but if you really can't, no problem, you're going to get a fresh start. The other most common consumer bankruptcy chapter is Chapter 13. Chapter 13 is a reorganization. A reorganization essentially means you're going to pay back a portion of up to 100% of your debt. Now, why a reorganization plan is different is for two main reasons. First, it allows you to reorganize missed payments on secured debt. Secured debt is typically a mortgage, a car loan, things like that, right? Where there's collateral behind the money that you borrow. So very common during the pandemic, people were unable to make their mortgage payments. And some banks gave mortgage assistance. They had a deferment of a couple of months. But eventually that all went away. And if you couldn't make up all your missed payments, you're now facing a potential foreclosure and you're going to lose your home. Well, Chapter 13 allows you to take those missed payments and pay that back over up to a 5-year period of time. And depending on your income and your what I would call like what you've got left over, you may end up paying 0% to all the other unsecured creditors. You may have just enough to make those secured payments. You may pay back 2% out of all of your unsecured debt on top of those secured payments. You may pay back 100%, depending on the amount of the unsecured debt, the amount of missed payments you have, and your income. But Chapter 13 is a way to keep your assets, pay back creditors over a structured period of time. Usually it's without interest and penalties. It's just sort of a set amount. And you don't risk a liquidation by a trustee. So those are your basic three. Chapter 11s can be filed by individuals under certain circumstances. Usually it's when the individuals have greater than a certain amount of secured debt. So there's certain debt limits. So if I have over, let's say as an example, let's say I own 4 properties that are rental properties and I owe $2.8 million in mortgages on the 4 properties. Well, I would have exceeded the debt limit for like Chapter 13. So I can only do Chapter 7 to just liquidate, right. Or if I want to keep everything, I can only then do Chapter 11. Right. And then it's not even 100% certain if we can do Subchapter 5, because those are for operating businesses and there's certain other criteria that you have to meet. But again, for individuals that bought a couple of different houses and have been saving up and they're sort of building their little American dream empire, you can keep everything, but you're going to have to pay back some money.
And I'm glad you brought that up, because a lot of the questions also were people being scared that their properties were going to be taken away from them or that they would lose their house. That was the main concern in most of our comments was, will I lose my house in the bankruptcy? And I feel like that's why people are mostly scared to go and file for it as well.
So that's a good point. It's a fear that is unfortunately perpetrated by probably people that got some bad advice in the beginning, or maybe were less than upfront or honest with their attorneys. Chapter 7, you're allowed to take certain exemptions. An exemption means that particular money, cash, asset, equity is protected and cannot be liquidated. So in California, in Los Angeles, we have a higher homestead exemption than a lot of other states, or the federal homestead exemption. So, for example, you can usually protect up to $600,000 of equity in a home, not lose your house, keep it, and still file Chapter 7 and wipe out all your other debt. Now, you have to be current on your mortgage, right? If you try to file Chapter 7 and you're behind on your mortgage, there is no repayment plan in Chapter 7. But if you're behind, then you do a Chapter 13. But if you're current on your mortgage or your car loan, and you just want to get out of all your credit card debt, and if you've got less than $600,000 in equity, you can still do it, assuming your income doesn't exceed what's called the means test, which is sort of a federal standard for median income, and that deals with the number of people in the household, and if you have minor dependents, how much your rental mortgage payment is, and stuff like that. But we filed Chapter 7 for people that had $9,000 mortgage payments, but that's where their income went. They didn't have more than $20,000, $30,000, $40,000 of equity, but they could have had up to $600,000. We could have still protected everything, wiped out.
So when you say wipe out your debt, most people are under the impression that all of their debt will be wiped out. There are certain ones that will not be wiped out with bankruptcy, correct?
That's right. So student loans are not normally dischargeable. There is some movement as far as changes in that policy under the Biden administration, but it's not a science yet, and a lot of bankruptcy practitioners aren't quite sure how to do it. Domestic support obligations, so alimony and child support, are not dischargeable in bankruptcy. So you can wipe out everything else, but you got to pay those. Certain type of tax debt is not dischargeable, or it has to be delinquent for a certain period of time. Usually it's 3 or 4 years. And then you can wipe out certain IRS debt or state of California, like, income tax debt. But it's not a given. It's not guaranteed. And this is probably the most difficult thing for people to understand and deal with, is there are certain exceptions to wiping out debt in bankruptcy that deal with debt that was incurred by fraudulent means or deceit, things like that. And so, by way of example, and I can't give, of course, specific names, but
of course,
maybe 8 or 9 years ago, I had somebody come in for a consultation. They had $85,000 in credit card debt. That's an awful lot.
Yeah.
So I asked him nicely, well, what is it you do for a living? Well, he worked at a car wash. He made $17 an hour. And it was part-time. So my first question was, well, just help me understand, how were you able to get $85,000 worth of revolving credit? And it came out little by little that essentially these were scams, that people would use guys like this to get credit cards. They would instruct them to cash advance on them or buy merchandise, and then they would sell them off on eBay or whatever. They would give these people a few $100 or $1,000, they would keep the rest and then say, yeah, don't worry, just don't pay it. There's nothing you can do, and then file bankruptcy in this. Well, debt that's incurred that way is fraudulent. Right? So bankruptcy doesn't let you get out of it. But the creditor has to do something in your bankruptcy. Like, it's not just automatic. They have to file what's called an adversary proceeding, which is like a lawsuit within the bankruptcy, but the scope of those lawsuits are limited to whether or not a debt is dischargeable, or whether all of your debts are dischargeable, even depending on certain types of frauds or omissions. A good example of when none of the debt is dischargeable is when a person files bankruptcy and intentionally omits or fails to disclose certain assets because they don't want them sold or liquidated, and the Office of the United States Trustee or the bankruptcy trustee finds out about it. That omission, especially if it's intentional, can result in that person being denied a discharge, period. So the whole bankruptcy would have been for nothing. So yeah, you have to be really careful about how debts are scheduled. Definitely have to tell your attorney everything.
Of course.
Right? And the other very common example is when it's sort of like personal for people. So we've had more than our fair share of clients that went into bankruptcy that had personal loans, like they borrowed money from a friend. And now all of a sudden the friend's like, oh, you're a fraudster, you're a con man, you stole all my money, you ripped me off, you told me you need money to fix your car, and then you went to the horse track or whatever. And usually those don't rise to the level of that kind of fraud, but people get like really emotional about it. Money, does all sorts of crazy things to people.
Of course.
Well, here as future episodes go, I'll tell you the audience stories about some of the craziness that happens. Tell you guys a story about something that went from $120 million to zero overnight.
Jeez.
But I digress. But the point is that everything has to be disclosed. Follow your attorney's advice. He should know what debts could be problematic. He may ask for better explanations, may want to know the circumstances behind certain things, and then he can best advise.
And stop lying to your attorneys. Just be honest. That's all you have to do. It's your attorney. They're on your side.
Well, people don't always remember that everything that's discussed between an attorney and a client is privileged.
Of course.
So that can never be discussed publicly with anybody unless the client authorizes it.
Right.
Now, there's exceptions to everything, even that. So, for example, if a client sends me an email with confidential information but copies his ex-wife or whatever that's no longer privileged.
Right.
You opened it up to third parties. But any direct communication between attorney and client, that's 100% sacred. That's sacred.
Yeah.
So, yeah, don't be afraid to tell your attorney everything. Unless you just, you're afraid of being judged. But otherwise,
Of course. All right. So speaking on bankruptcy, after you come off of bankruptcy and that's done, how long do you think a person should wait to get like a mortgage after that if they want to get a mortgage?
So a lot of that depends on the chapter you file.
Okay.
Most people are eligible to qualify for mortgage loans 2 years after a discharge in Chapter 7.
Okay.
But what's interesting about Chapter 7 is people will start getting offers for like car loans and even new credit cards 3 months after they file Chapter 7. And there's a very specific reason for that. And Chapter 7, remember, is like a wipeout. So you actually become a better credit risk because you're not going to have to pay all that other stuff.
Right.
You just have to pay this one new loan. So this new car loan, or, you get one new credit card with a fairly modest, limit, maybe $500, $1,000. But you don't have to pay anybody else, right? You just have to pay that one. And that's how you rebuild credit. And again, you're lower risk. So somebody that has perfect credit, never missed a payment, but is maxed out on all their cards and has 3 car loans on it, they're not as likely to get new credit extended to them as somebody that just came out of Chapter 7.
Right.
They don't owe anybody anything anymore, right? So now it's like, okay, well, you have a job, you make this much, and you don't have to pay anybody else but us. All right, we'll give you a shot. And of course, we're going to charge you some outrageous interest rate, but that's all part of the rebuilding process.
So what would happen if in a bankruptcy someone went and let's say got a card or got like a mortgage in the middle or anything like that?
Usually banks won't approve mortgages while they're still in a bankruptcy. Chapter 13 and Chapter 11 typically can go from 3 to 5 years over this course of the payment plan. And that's once a plan is confirmed by the court.
Okay.
That's a whole other process that we can get into on a different day. That's actually fairly complex. But once your plan of reorganization is confirmed by the court, which means the bankruptcy court, United States Federal Bankruptcy Court judge, basically gives it a seal of approval. Okay, we've dealt with all the objections and issues, and this plan can go forward as written or as amended or whatever. you're not going to really get like a mortgage loan.
Okay.
And if you do have to incur new debt in a Chapter 11 or 13, you have to file a motion and ask the court for permission. Now, the most common thing that happens in Chapter 13 is somebody needs a new car. Because, Chapter 13 can go 5 years, right? Mm-hmm. And in 5 years, life happens.
Right.
People need to get to work. They need to continue supporting themselves, their families, make their payments. So you can file a motion with the court and say, look, my car broke down. I need to finance a vehicle. I've got this company willing to do it, but the court has to approve it. 99% of the time, the court will do it as long as you're not saying, but I need, a new Porsche.
Of course.
Something like that. But if you're just buying a modest car to get you to and from, no problem. The other really common thing is if people need new appliances, right? Their stove breaks, their refrigerator breaks, and they have to finance it or buy it on terms. Courts will almost always approve that kind of stuff. I had a case maybe 5 or 6 years ago where actually it was a husband and wife that filed, and the wife needed dental work, and she had to finance these dentures or whatever, right. Dental implant, whatever it was, and it was $13,000. She had to do a whole mouth. I don't know, some kind of money. But the court approved it. Yeah. Let her finance through the dental plan financing, and made her payments and with interest and all that. But and again, there's certain exceptions to everything, and there's some complexities that go along with all that. But for purposes of today, that's what you usually can do. Buying a house and taking on an asset essentially when you're not paying 100% to all your creditors, that's going to be a no.
Okay. So after the bankruptcy and all, how long do you think it would take someone to fix their credit score after filing for bankruptcy?
Well, interestingly enough, Chapter 7, your credit score usually goes up 20 or 30 points a month after you file.
Oh, interesting.
Yeah, because again, you're not going to have any more debt. It's
right.
a fresh start.
Right?
Yeah. Chapters 11 and 13, that takes a bit longer because those cases last and they stay open longer. Mm-hmm. A bankruptcy filing is a public record. It's a court filing. So that goes on your credit report as a public record, just like a tax lien would or a judgment or anything else. Those stay on, I think, 10 years.
Okay.
But what's important to remember is even though the bankruptcy shows is on your credit, that doesn't preclude you from getting new credit or getting new credit cards or getting a loan. You start building credit again pretty soon after you file.
Okay. All right. So is there anything else on bankruptcy before we start our next segment that you wanted to talk about?
No, we should listen. Yeah, bring on the question. I could talk about bankruptcy. We need something for future episodes. So.
All right. So let's start with our segment of what Eric would do. And these are questions we found on Reddit on people needing help with bankruptcy.
Okay.
All right. All right. So our first one would be, the title is Debt Collector After Bankruptcy. So I divorced my ex in 2012. We are in debt. I filed bankruptcy in 2013 and it just got off of my credit report. My ex died nearly last year. He never filed bankruptcy, and now I have gotten calls from a collection agency. I have nothing on my credit report, and I don't answer any phone calls. How would I handle this?
The first thing I would do is send the collection agency a copy of her discharge. I would also send them a notice of the death certificate, let them know that they were divorced. They were divorced 10 years ago. When somebody receives what's called a discharge in Chapter 7, mm-hmm. that comes with what's called a discharge injunction, which prohibits any attempt to collect debts that are called pre-petition, meaning debts that were in existence prior to the bankruptcy filing. Literally every debt up to the minute that the bankruptcy was filed, that's part of it. So I think that she may have some good grounds to get sanctions against these debt collectors if they continue to persist in harass her.
Okay. Next question. Bankruptcy versus bad credit. Which is worse to have, a bankruptcy or bad credit? When applying for a car or a house, even renting, they'll ask if you've ever filed for bankruptcy. So which is worse?
It's hard to believe that's a real question because I think bad credit is probably a lot worse. Because I think bad credit just shows that you're, for lack of a better word, kind of like a deadbeat,
Right.
If you file bankruptcy, look, lots of people file bankruptcy. American Airlines filed bankruptcy. General Motors filed bankruptcy. Trump had 4 organizations file bankruptcy. Bankruptcy has a stigma from generations past, but it's really not like that today. So I would definitely, of course, I'm a little bit biased being a bankruptcy attorney, but I definitely think bankruptcy is, especially Chapter 7, you're better off to do that, wipe out your debt, and just start rebuilding.
Of course. All right, next question. What should we do with my father's inheritance after a bankruptcy? My grandma died a couple of years ago and left an inheritance to my father. She died while he was in the middle of a bankruptcy, but he didn't actually receive the money until after his bankruptcy concluded. He currently has possession of the money. Is he able to keep his money since the bankruptcy is over, or is it possible creditors will come after it? It was a Chapter 13.
Okay, that's a good question because inheritances are usually allowed if you get it 6 months after the bankruptcy concludes.
Okay.
And usually in chapter 7s or 13s, you will fill out questionnaires and they will ask you if you think you're going to get an inheritance or are you subject to an inheritance. So at some point, the unfortunate day is going to come where my father's going to pass away. My brother and I will get an inheritance. If I file bankruptcy today, I have to disclose that yes, I may have an inheritance someday. I don't know when. And then if I do receive an inheritance and it's within 6 months of my bankruptcy finishing, meaning a Chapter 7 discharge or a Chapter 13 confirmation and discharge, then I'm clear if it's after 6 months. If it's within 6 months, I have an obligation to report it to the trustee, and then they will take that, and that will go to distribute to my creditors.
Right.
But I cannot implore enough not to hide it. Trustees usually will find out. I don't know how, but they just seem to know everything, and you're always better off just being upfront about it.
Again, be honest, guys. So, all right. Bankruptcy question. I've heard that taking out loans and filing bankruptcy right after is considered fraud. But if that's the case, then how long would you have to wait after taking out a personal loan to file bankruptcy?
Well, it goes like this. There is something called first payment default, which is, there's a legal term called prima facie evidence of fraud. So yes, if I go take a personal loan, like, one of these like speedy cash loans or payday loan, and I don't make any payments at all, not even the first payment, or I borrow money for an LLC or whatever, that's almost considered fraud all the time.
Okay.
Now, if I take a loan today, and let's say I take a payday loan, but I'm employed, and I get fired tomorrow, that's probably not fraud, right? Even though I don't make the first payment. So all the circumstances, everything depends on the circumstances. The question, though, the way it's framed almost makes me feel like this person's looking to find out like how to commit fraud. So I don't really want to get too into details like that, but generally, you need to make at least 3 payments and show good faith. And you also need to, number one, be very honest in your loan application. Like, do not overstate your income. That's fraudulent. Do not overstate your ability to pay. Do not overstate your assets. If that information is false and it's knowingly false, that's fraud. So better to just apply for the loans that you can afford if you really need them and try to keep up with your payments. Look, everybody falls behind at some point in life for some reason. There are unfortunate circumstances. There are layoffs and medical issues and divorces and deaths in families and sickness and all sorts of stuff like that. There are plenty of valid reasons for people to fall behind. So please don't be that guy that takes his payday loan, goes to the casino and says, well, screw it, I lost, so everybody else loses.
All right, next one. My dad is filing bankruptcy and trying to put the house in my name. Help. My father had surgery a few months ago, which cost him his job and most of his savings. Because of this, he's been behind on his medical bills for the sake of trying to stay on top of the utilities, mortgage, etc. Apparently, he got served, and now he's begging me to put the deed in my name for the house while he files for bankruptcy. I am incredibly wary, and I have no idea what any of this means and can barely afford my own lifestyle as I live in D.C. and it's pretty expensive. Can someone please help?
This is a little bit tricky, and D.C. I'm not licensed in D.C., so I don't want to give specific advice about Washington, D.C., but I can tell you this. Generally speaking, if you are the recipient of an asset transfer from a party that's going bankrupt, that transfer will be undone as fraudulent, and that asset will be liquidated. The thing to do is have your father look at how much equity is in the house and whether or not that equity can be protected based on the homestead exemption he might be eligible for. I don't know if the father lives in D.C. or just the son So it's going to be based on the state or whether they take the federal homestead exemption. But that's the first thing to do before anything else. But I would not recommend transferring assets right before you file bankruptcy. That's one of the biggest red flags that every bankruptcy trustee looks for.
Okay, next one. This one's just titled Bankruptcy. Hello all, I'm trying to find out what my options are. A family member and I co-own a house. I am the main borrower. He has a business that is about to flop and he has no other means at the moment other than to declare bankruptcy. He told me a while ago and I hurried and was able to refinance the house under my name and my wife's name and took him out of the title. My question is, if he does file for bankruptcy, can the government still come for the house?
Probably not, as long as there wasn't any fraud when they first procured it. People tend to refi and take people off title all the time. It could be potentially problematic if there's a lot of equity in the house and then the bankruptcy was done solely to wipe out debt and protect the equity that may belong to the brother. So it's hard to say. It also depends how much time goes by between when the refi and removing him off the loan happened versus when the brother files bankruptcy. It might be better to not file bankruptcy, to just, if he has no other assets and no business and he's not entitled to that house anymore, he seems like he'd be judgment proof, which is kind of a term of art. But if you have no job and no assets and no income and not a lot of money in the bank, there's not a whole lot of judgment creditor can do to you.
Right.
It might be better to wait a while, a couple of years for that transfer to kind of set in and be out of similar to like a statute of limitations for a fraudulent conveyance action, and then just file them.
Okay. Next one. Is it possible to file bankruptcy without hurting my spouse? Basically, as the title states, I have done a lot of damage on credit cards, and I hate that I'm hurting my husband. Our house, our cars, they're all in his name.
I'm sorry. Wait a minute. What? There's a wife out there that racked up credit card debt for and doesn't want to. No, say again, son. Those can really happen.
Well, their house and the car, they're all in his name. But would her filing bankruptcy to wipe her place as a, sorry, she worded this weird. Would her filing bankruptcy to wipe her slate have any impact on his credit?
A spouse can file without the other spouse.
Okay.
That is not an uncommon thing to do because you can often preserve one spouse's credit. The problem they're going to have is if certain debts are going to be community, if they live in a community property state, I don't know where they live, but if this were California, you can list. In fact, one of the questions they ask you, say in Chapter 7, is, did you list all your assets? Did your non-filing spouse list all of her assets? Did she list all of her debts? Did you list all of your debts? So everything is going to be included, right? Because it's community. Car, house, in certain names, again, that's not as powerful as people think because, again, if it's a community property state, then the equity belongs to the bankruptcy estate. Most people don't realize that if there's a home that's owned by a married couple, even if it's in one spouse's name, right, because it's a community property state, that asset would belong to the bankruptcy estate. So, I appreciate, trying to be slick and, not force her husband to have to pay all these ridiculous credit card bills for whatever nonsense she was buying, but probably not a great idea.
All right, this is the last one we have, and it's a little funny, so hear them out. Is it suspicious that my mom is filing bankruptcy for my dad via power of attorney? That was the title. My mom works from home and asked me to sit outside on the sun porch since I wasn't leaving for work yet because she had a meeting. It's an open floor plan house, and I just keep quiet if she has a meeting, but she asked me to go outside, so I did. I went down to her chicken coop to feed her chickens and find the eggs, all since I'd be around a little while longer. I figured that I could sneak back into the house and put the eggs on the table if I was quiet about it, but I heard my dad's name and the talk about filing bankruptcy as a power of attorney. My parents are divorced, but my dad has had a major stroke 10 years ago and he lives here. He is fully cognitive and he gets around pretty well and just has some vision and balance issues. I wouldn't think it was weird, but then she came out to tell me I could come back in and she acted like it was just a work call and she needed me to sit outside because they were discussing personal patient details. So it just seems weird.
You know what seems weird is the whole going out to the chicken, right? Like bringing the eggs and then having to sneak eggs back in the house. That's weird. This is a weird thing.
It was.
But, okay. It's really not an easy answer because there are certain exceptions and carve-outs in the bankruptcy code that allow somebody to file on someone else's behalf, mental incapacity, things like that.
But they're divorced.
Well, but she has a power of attorney, right? So if she's a primary caregiver and she has the right to make financial decisions, she could, in theory, file bankruptcy on his behalf using the power of attorney. But and I say this with a big, big, giant however, if he is lucid and he has his mental faculties, he should probably undo the power of attorney, right, at this point, or maybe have like this overly concerned son not pay too much attention to the chickens and try to help his dad.
Yeah, and go, hey, Dad, what's this about mom filing bankruptcy for you?
Not just that, but if the stroke was 10 years ago and he can get around and he can, communicate and he has his faculties about him, why does he need someone with a power of attorney at this point? So, yeah, that sounds a little sus. I'd be a little concerned about that. I mean, the chicken thing is concerning too, but having to sneak in and,
she was on a call.
Yeah, like the porch. I get it. Let's just tell Elmer whatever. Just better to have her dad undo the power of attorney or get his own counsel.
Yeah,
to help him.
Yeah. All right. I think that wraps up the first episode, and we covered all of bankruptcy.
Visit our website www.eblawfirm.us. You can also email us at info@eblawfirm.us. You can send us all your questions. I may not reply to the email. That's because I don't want you to think we have an attorney-client relationship, but we may read them on the air for the next podcast, and I may give you a general answer. So there you go.
All right. And you can find us on Twitter. You can find us on Instagram at The Balsamic Confirm. We're also on TikTok as The Balsamic Confirm as well. And you can DM us on TikTok and Instagram, and I will reply. All right. Thank you guys for listening.